complementary compliance of the document, in order not to violate and not to interrupt with the relations between the seller and the buyer. Because the relations between the seller and the bank are a different level of relations. And if this got furthermore, we would like to state that in all jurisprudence which state that general reference is sufficient to bind the parties, there were no jurisprudence with regard to the letter of credit. And the letter of credit is autonomous, and it cannot be equalized with the standard terms and conditions which were referred to in that jurisprudence.
So, the letter of credit, you would agree, is actually setting out the obligations of the bank. Is that correct?
Exactly.
So, if the bank is setting out its obligations in the letter of credit, and those obligations include an express and explicit reference to a specific contract, are you saying that the bank should not have known, even if we accept that it did not know, that it should not have known what those terms are?
We submit that no, due to the autonomous character of the letter of credit stipulated in Article 4, and due to the fact that the bank initially provided a different interpretation of this clause and did not mean by any means to interpret it as a reference to the provisions of the shipbuilding contract.
But there's a clear express reference to the contract, and it says which shall have the full effect.
Yes, as we stipulated earlier with regard to the second part of the full effect with regard to the terms of the letter of credit, the only meaning that the bank was given to these terms is that the buyer to comply with its obligations under the shipbuilding contract.
But how could they have had that interpretation if they weren't aware of the terms of the contract?
But because the bank received the instructions from the applicant, from the buyer, who opened the letter of credit, and under UCP, the banks include the terms which the buyer provides him with, the instructions from the buyer. If this court has no further questions regarding the arbitration clause, we would kindly refer to the suspension of current proceedings. In the issue of suspension of current proceedings, we would like to address that the continuations of these proceedings will not lead to contradictory awards. Two principles that were designed to avoid contradictory awards are lis pendens and res judicata principles, and they are applicable when the triple identity test is satisfied. It means the same party, the same subject, and the same cause of action. And we do not contest that the criteria of the same parties is not satisfied in both tribunals. However, we submit that the triple identity test is still applicable here. As was stipulated by the International Law Association in its interim report on lis pendens and res judicata, that the general principle is that the same parties is involved in both proceedings, but there are exceptions to this rule. And the exception is that the suspension may take place where one party has substantial interest in the outcome of the other proceedings. And it is so-called identity of interest criteria. It was accepted in both common law countries and civil law countries. And we can provide this honorable tribunal with the case study and doctrinal resources that stipulates it. And furthermore, we submit that the continuation of these proceedings will lead to abuse of cost-effectiveness and expeditious principles, which are envisaged in Article 22 of ICC rules. And validity.
Just to clarify your submission, this submission that if the established conditions for the lis pendens here are under obligation to suspend, or we have discretion whether to suspend it.
Of course, this tribunal has discretion pursuant to the provision 41 of the International Chamber of Commerce rules on the international arbitration. And the validity of Acceptance Act is subject to consideration in both proceedings, in these proceedings and in proceedings 1988. And we submit it will be, from the financial point of view, not efficient to establish the validity of the act in both proceedings. For this reason, we ask the court to
How
suspend.
expensive it is to establish that your client is the individual who either signed or didn't sign?
We submit that it will be.
And also your client will be required to produce this evidence in both arbitrations. I mean, this examination will need to be carried out anyway.
Yeah, but in not in the present. Not the bank will be examining the validity of the Acceptance Act in the Tribunal 1988. For this reason, we ask the court to suspend the procedure and consider that the arbitration clause in the shipbuilding contract is not bind the bank. And I now give the floor to my colleagues.
It's just unclear to me how, even if the other tribunal were to make any kind of finding of fact with respect to the validity of the strictly acceptance, how in any way that would be, first of all, how could it be produced in this incident, given the confidentiality of the, and secondly, how in any way that would be influential or would we be bound by that decision? So answer that, I have one more comment.
Thank you very much. Considering the force of the finding of the other tribunals, of course, we confirm that these tribunals is in no way bound by the previous finding of the other courts. However, as it was stated in case Sapem versus Bangladesh, the tribunal considered that it is not bound by previous decisions. At the same time, it is of the opinion that it must pay due consideration to earlier decisions of international tribunal in order to make a series of consistent cases, so not to avoid contradictory awards. And furthermore, this tribunal may take any step to take any evidence pursuant to the ICC rules and its rules stipulated in paragraph. This rule is stipulated in Article 12 of the ICC rules. With regard to the confidentiality issue, we submit that the ICC Tribunal, International Chamber of Commerce, has itself provided us with disclosed the confidentiality of the other tribunal, and therefore it was page 43 of the case study. Where it wrote you may apply for an extension of the time for submitting your answers. Excuse me. It's exhibit. In this exhibit, the ICC disclosed the parties of that tribunal and said that this tribunal may apply to the findings of the tribunal in case number 1918.
The follow-up question then is, how, as it's in the tribunal's discretion, how it would, as a matter of practice, would justice be served by suspending these proceedings? Why would it be just to do so? In other words, would there be savings of costs? Would there be some more efficiency as a practical matter?
From what point of view, Mr. Arbitrator, do you refer to the practical matter from time-saving purpose?
Anything that you suggest, but what as a matter of practice how would justice be better served by suspending these proceedings?
The respondent considered that the justice would be better served if this procedure will be suspended, due to the fact that this tribunal will also establish the validity, will need to establish the validity of the Acceptance Act, because the falsificated document cannot be a compliant presentation. So this tribunal will also need to establish the validity. And establishing the validity in both procedures will may lead then to the application of avoiding the contradictory award. First, this tribunal, the parties of this tribunal will spend more. If the tribunal, the proceeding will be suspended, the party will not spend additional money to conduct the checking of the validity of the check of the signature. And with regard to the time-consuming issue, we submit that it might be the thing that the other arbitration has already established the validity of the arbitration of the Acceptance Act. And if they did so, because the other proceeding started earlier than this proceeding, as it is evident from the clarifications. So from the point of view of time consumer, it will be more efficient as well. For this reason.
We still need to make our own independent decision, irrespective of that tribunal.
Of course, but it is fair to make independent decisions in each tribunal.
Okay. Is the resolution on jurisdiction?
Yes.
Okay, do you have questions? Do you have questions to the answer? No. Now we'll give the floor to the claimant. I understand that we'll be speaking on our jurisdictional issue.
Members of the tribunal, my name is Alex Kemuth, and I'm counsel for the claimant in this proceeding, MM Lux Yachts Limited. I will address the jurisdictional issues at play in this case. This case comes down to 3 words: pacta sunt servanda. Promises must be kept. The bank must be bound by the promise that it made under the terms of the letter of credit. This tribunal should proceed with this arbitration for 3 main reasons. First, the bank's consent to arbitrate is manifested through the incorporation by reference of the arbitration clause in the shipbuilding contract into the letter of credit. Second, this proceeding should not be suspended until an award in the other proceeding is rendered, because the requirements as promulgated by the ILA for addressing this very type of situation are not met. Thus, the burden falls upon the respondent to show why this tribunal cannot proceed. And third, this tribunal has the jurisdiction to determine, if necessary, the validity of the Acceptance Act and the amount to finally be paid to the claimant. It has been asserted that it is impossible to extend the arbitration clause of the shipbuilding contract to the letter of credit. Yet, I will show that the arbitration clause in the shipbuilding contract does extend to the parties in this arbitration. An incorporation by reference scenario occurs when there is a reference in one document to another document that contains an arbitration clause. An essential part of this analysis is to look to the intent of the parties. Article 10 of the letter of credit reads as follows: this letter of credit is issued without prejudice to the shipbuilding contract, which shall have a full effect with regard to the terms of this letter of credit. And reading Article 10.1.2 of the shipbuilding contract, that states, all disputes between the parties will be resolved by ICC arbitration in accordance with the best principles of international trade law. A claim has been raised that there was no intent on the part of the bank for Article 10 to incorporate this arbitration clause that I just read. However, a fair reading of Article 10 evidences the bank's intent for the arbitration clause to apply through incorporation by reference. It has been asserted that the reference in the letter of credit as written is not sufficient, but I will show that the reference as written functions to effectively incorporate by reference this arbitration clause. And this reading is supported by the UNCITRAL model law, which states that you simply need a reference in a contract to incorporate by reference an arbitration agreement. And here, the reference is clear. Why is this? First, the bank itself said so. The express language of Article 10 shows intent. It says full effect. It shows.
I'm sorry, can I ask you, can it have intent if it hadn't seen at the time of the contract itself? Can it be said that this reference is an official intent if you didn't know what it was consenting? Specifically about arbitration.
We submit that the bank was aware of the terms of the shipbuilding contract because the bank, a sophisticated party, would not include full effect without having read or been aware of the terms of the shipbuilding contract.
I'm sorry for interrupting. I have a question. This idea that the bank did not see the contract and we should not have paid it, it comes from the terminals or it was actually
They did not possess the shipbuilding contract at the time because
how do you know?
because the shipbuilding contract was provided only on the 7th of March when the seller made a presentation of the document with the request to pay $11 million.
Once again, so the shipbuilding, the contract was presented what?
On the 7th of March 2015,
Okay.
and the letter of credit was issued on the 5th of March 2015.
Before.
Yes. So until the 7th of March, the respondent did not possess the notarized copy of the shipbuilding.
But it does not come from the case now, right? This is your construction of the evidence. So we are saying there's no evidence that the contract was presented to you at the time of letter of credit issue, right?
Yes.
So, and you have different interpretation now of the evidence.
Well, we submit that that characterization is not necessarily the case. I think what's important here and what has been submitted in submissions and in the record is that it's clear through an interpretation that this tribunal can make is that the bank was aware of the terms of the shipbuilding contract. And why is this? I'll explain. The bank, a sophisticated party, would not include the language of full effect without having been aware of the terms of the letter of credit. The presumption under the UCP is to not make these types of references to other documents. The bank is aware of the terms of the UCP 600. It's the governing law of the letter of credit. And therefore, by choosing to make a deviation at the specific behest of its client to include the language full effect and to make a reference to the shipbuilding contract, we would argue and we submit that the preponderance of the evidence would be that the bank would be familiar with the terms of the shipbuilding contract. There's no reason for the bank to include the language full effect without it being familiar with the terms of the shipbuilding contract. And that's what the language of Article 10 reflects. And so it reflects their agreement to arbitrate. That's the meaning of full effect.
Before you come to arbitration, what do you mean by full effect?
Full effect, and as written, and I'll just refer back to Article 10 of the letter of credit. It states, it's issued without prejudice to the shipbuilding contract, which will have a full effect. So that means that all the terms of the shipbuilding contract that are not in contradiction specifically with the terms of the letter of credit should apply. And that includes.
That means that the bank assumed joint liability with the buyer for all terms of the contract by issuing this warning. Should have full effect.
We respectfully submit that obligations under the shipbuilding contract are distinct from obligations under the letter of credit. The only obligations that the bank has in this proceeding is to fulfill payment under the letter of credit if there's a valid submission presented to it.
Then what full effect means?
Full effect means basically that if there are terms that are in the shipbuilding contract, for example, governing law, as well as the clause regarding arbitration, I would point out again that this letter of credit is silent as to a specific dispute resolution mechanism. Therefore, the language full effect in this tribunal makes sense for this tribunal to understand the language of full effect, therefore necessarily incorporates the desired dispute resolution mechanism under the shipbuilding contract into the letter of credit. There's no other meaning of full effect if that is not the case. We cannot pick and choose which terms have full effect. All terms should have full effect under the clause that's written.
And what does it mean without prejudice? How it should be read together with full effect?
We submit that the reading of without prejudice relates to terms that would specifically contradict terms of the letter of credit. So, for example, if there was a specific dispute resolution mechanism in the letter of credit itself, then that would be a case of contradiction and the letter of credit would prevail. However, that is not the case that we have here. We have a dispute resolution mechanism in the shipbuilding contract. There is not a similar mechanism in the letter of credit, and so that is the meaning of without prejudice combined with full effect. And it is clear that the arbitration clause binds the respondent. There is no limitation on parties in this clause. It does not restrict itself just to the buyer and the seller. So therefore, a fair reading of this clause would mean that any dispute...
Isn't it also the case that only buyer and seller are parties to this agreement? So that if the term parties is used in the agreement, in the contract, doesn't it refer to parties to that?
Buyer and seller are performing the fundamental obligations of the shipbuilding contract. However, the clause as written does not specifically limit the parties referenced in the arbitration clause to just the buyer and the seller. If the buyer and the seller...
Are you submitting that the bank is party to that?
No, I'm not submitting that.
So how can it be treated as party? And this is specifically refers to dispute between parties.
Yes. What we submit is that a fair reading of this arbitration clause would mean that any dispute, whether it be the seller versus the buyer versus the bank, or the bank versus the seller, is necessarily covered under the universe of possibilities of the arbitration clause as written. Because the parties, because the builder and the buyer do not specifically limit that clause just to seller versus buyer, therefore this universe of three possibilities that I've laid out is applicable, and there's no indication in this clause otherwise.
This is a sophisticated bank. This is a letter of credit for $11 million. If it was the parties of the bank's intention to arbitrate a dispute, wouldn't you not have expected a much more clear agreement in the letter of credit with respect to arbitration, rather than a vague reference to another contract?
We submit that the reference is indeed clear. It says full effect. It says without prejudice. It is a sophisticated bank, as you pointed out. It is aware of the UCP 600. It knows that once it deviates from the norm of the UCP 600, which is to not make these types of references, it will be held to account for its decision to do so. So we submit that the bank completely believed that in a scenario involving arbitration, it would be held under the clause as written. And it has been asserted that this proceeding should be suspended, yet I will show that it should not be for the following reasons. The ILA recommendations constitute a summary of international law in this area. It deals with parallel proceedings, and the legal doctrine in this case is lis pendens, which refers to a situation where there is one arbitration filed before another. And it has certain requirements that must be met. These requirements are the triple identity test. You must have a similarity on issues, cause of action, and parties. None of these are met here. The parties of this arbitration is the seller versus the bank. The other arbitration is the buyer against the seller. In this arbitration, the issue is to fulfill obligations that are a valid and binding letter of credit. In that arbitration, it's regarding a breach of a shipbuilding contract. There are different legal standards and issues that apply. For example, here, they're applying the UCP 600. There, they may be applying the CASG or other applicable law. And the cause of action here is arising out of a letter of credit, while in case, it's arising on the shipbuilding contract and a breach of its terms. And therefore, because there's no lis pendens, the ILA standard is clear. It's presumption to proceed, and the burden is on the bank to show why there should be some.
Specifically with respect to the issue of forgery of the act, isn't the issue the same in both applications? I take your argument that the broad issue is different with respect to this specific issue.
So if either tribunal makes a determination regarding the validity of acceptance act, that doesn't necessarily have any binding effect on the other tribunal. We're using different legal standards and lenses and issues here. And so the determination...
How is the standard different?
The standards, for example, here in the UCPs that did the claimant make a submission on its face that the bank could have made a conceivable final determination, my colleague will show that they did. In that case, there's different standards. The honest fee standards probably would not apply to breaches under the shipbuilding contract.
I have one fundamental problem with this our recommendation because both parties are referring to it, and we will analyze triple identity case whether it is met or not as a ground for suspension. But my question is it triple identity case or suspenders under ILA recommendations? The recommendation is the only ground on which tribunal should suspend this application, because there might be some other grounds, like efficiency and so on and so forth.
We submit that this is the basis that is most convincing for this tribunal to determine whether it needs to suspend. As I stated earlier, it reflects the consensus of international law in this area. Scholars and formulations of this guideline have decided this is the best way to resolve it. And as I've shown that requirements of this test, which is considered a lot of these factors that you're concerned with, this tribunal very well should be. Therefore, that should be the test that this tribunal applies. I see that my time has expired, but may I have additional time to conclude my third issue? Thank you. So, despite assertions to the contrary, this tribunal can determine the validity of the Acceptance Act and the amount to be paid to the claimants, if necessary. So, it is not necessary to address the validity of the Acceptance Act. And why is this? Because if this tribunal determines that there was a final determination made on the part of the bank, the claimant wins this proceeding. If this tribunal, however, determines that there was not a final determination made on behalf of the bank, then it definitely has the authority to examine the elements and see if they're valid. Again, there is no lis pendens present. There is no limitation on the authority of this tribunal. The burden is on the respondent to